Before this committee, Assistant Director Steinbeck said that the concerns in Syria is that we don't have the systems in place on the ground to collect the information to vet. That would be the concern. Databases don't hold the information on these individuals. Is that still the position of the department?
Yes, I think that's the challenge we're all talking about, is that we can only query against that which we have collected. And so if someone has never made a ripple in the pond in Syria in a way that would get their identity or their interests reflected in our database, we can query our database till the cows come home, but we're not going to, there'll be nothing show up because we have no record on that person. That's what Assistant Director Steinbach was talking about. You can only query what you've collected. And with respect to Iraqi refugees, we had far more in our databases because of our country's work there for a decade. This is a different situation.
We judge that ISIL is training and attempting to deploy operatives for further attacks. ISIL has a large cadre of Western fighters who could potentially serve as operatives for attacks in the West. And the group is probably exploring a variety of means for infiltrating operatives into the West, including in refugee flows, smuggling routes, and legitimate methods of travel. Further,
Mr. Burson, Secretary Johnson is quoted as saying that there were legal limits on his ability to do some background investigations. I think that was a really unfortunate phrase that he used, but let's you and I see if we can kind of demystify that a little bit. Do you agree that non-citizens who are not in the United States are not afforded any protections under the Fourth Amendment?
That's my understanding, Mr. Gowdy.
Well, you were a U.S. attorney. You're being modest. Not only is that your understanding, it's also the law. The Fourth Amendment does not apply to non-U.S. citizens who are not here any more than the Eighth Amendment applies to non-U.S. citizens who are not here. Would you agree with me that there is no legal bar to accessing data from non-citizens who are not present in the United States?
Absent a treaty to the contrary, that's my understanding, sir.
Would you also agree with me that there is no legal right to immigrate to the United States? It's a privilege that we confer on people, but it is not a right.
That's correct, sir.
So would you also agree that you can condition the conference of a privilege on just about anything you want, so long as you don't violate a treaty or
the Constitution?
Or the Constitution. But you made, I'm sure, extensive use of polygraphs when you were the United States Attorney.
From time to time, yes, sir.
All right, and they're not admissible in court, are they?
Not generally, no.
But we still use them because they're a very effective investigative tool. Do we use them in the vetting of people who want to come here?
With regard to immigration benefits, I'm not familiar with the policy in the refugee context. We do not regularly use a polygraph. If there's significant doubt in the operational component, given the border authorities that ICE and CBP have, typically the decision would be made to bar entry rather than to go to the extent of trying to ascertain veracity.
But you and I didn't just use polygraphs in our previous lives because we had doubt. Sometimes it incents the person to want to embrace the truth when they think it might be a threat that they're going to be polygraphed. I mean, you certainly can't admit it in court. So it's not only the result, deception or otherwise, it is the threat that you may be polygraphed that sometimes provides people with the incentive to either tell the truth or they need not apply in the first place, right?
That can be one reaction from an individual, and I'm not aware, Mr. Gowdy, of any policy that would prevent that. I'm also not aware operationally, as a former CBP commissioner, that it's been used in any regular way.
Well, let me tell you where I find myself. I just listened to Ben Rhodes give a series of words like extensive, thorough, careful. I have heard tough. I have heard multiple, all in connection with the word vetting. It's all amplified the word vetting. And I just sat here and thought, well, if all of that was true, how did we miss the lady in San Bernardino?
As The FBI director said, Mr. Gowdy, and I think is the fact that there was nothing in the system that we used that would pick that up. There was no data that we would turn into actionable information to deny admission.
I get you, Mr. Burson, but I got to be candid with you. That doesn't make me feel any better. I mean, it's one thing to argue that there was information there and we missed it. That's one set of corrective measures. Right. It's another thing to argue, as I hear we are currently arguing, this administration, that we missed nothing. So we have someone willing and capable of killing 14 people, and there was nothing in her background that this administration says we missed or should have picked up on, and yet there's still 14 dead people. So how does that make us feel better?
Mr. Gowdy, I think I don't think anyone would gainsay the sense of tragedy, and I don't think anyone's saying that were that information, that data in the system, that we would not all be relieved and thankful if it had led to the apprehension of those murderers. But the issue that you asked is factually, were there data in the system by which we could tell that this risk existed? And the answer to that is no. I think the inquiry that's being made here today is a valid one, as Director Rodriguez suggests, and that we need to actually look at this hard and long in terms of the utilization of means. I will say that there is no secret policy in DHS against the use of social media, and there is nothing in the privacy policy that would bar it for screening purposes.
Well, it couldn't be, because it doesn't apply to non-U.S. citizens. I'm out of time. I just want to tell you the dichotomy as I see it. We have a choice. We can either tell the American people that our process and our systems are flawed, and that we have missed information that is otherwise available, and let them deal with that, or we can just tell our fellow citizens, we missed nothing. We did everything we were supposed to do, and there's still 14 funerals in California, so you just need to get used to the risk. Neither one of those is acceptable, I would argue to you.
Mr. Gowdy, I've not heard anyone who was involved in law enforcement or in the Homeland Security enterprise that wouldn't say that we need to strengthen our systems. We've been doing that continuously for the 14.
Gentleman's time has expired.
Right, well, I'm out of time, but I've got a couple other questions, and I'm sure the chairman will indulge me. Do you know whether the female terrorist in California was subjected to an in-person interview before her K visa was issued?
As part of the visa process, yes, that individual was interviewed.
Do you know who interviewed the person?
I do not have that information. That would be a question to ask the State Department.
Do you know how long the interview took place, how long it lasted?
That would also be a question for the State Department. They conducted the interview.
Do you know what investigation, if any, was done into her in terms of education, employment, social media?
Those are all questions that should be referred to the State Department.
Who has her immigration file?
USCIS would have the immigration file.
I thought USCIS was a subset of DHS.
Yes.
And you're with DHS, so why wouldn't I ask you?
So the process would start with CIS for a K-1 visa.
I know, and then it goes to the State Department.
And then it goes to the State Department, which is where all the checks to see if that individual is eligible for the K-1 visa. I'm sorry, I even lost my own train of thought.
No, I know exactly where you're going.
If someone is eligible, sorry, for the K-1
Mr. Rodriguez
visa.
was with us yesterday.
Yes. Then the individual would travel to the United States. Of course, there's vetting done on the individual as they travel, as any individual is. And then within 90 days, they can apply for legal permanent residency, and then that is also when USCIS would get involved and do biographic and biometric checks.
I understand the process, and I'm out of time. I'm just going to make this point before I yield back to the chairman. There's an application process for, we're not even talking about the visa waiver program. We're talking about the process where there actually is a visa issued. There's an investigation, there's an interview, there's another interview, and yet we still got it wrong. And I would think the chairman one of whom is sitting beside me, and Chairman DeSantis and Ranking Member Lynch, I would think that they would be very interested in her immigration file to find out what questions perhaps weren't asked that should have been, so we can learn lessons after the 14 are dead, and hopefully we can learn before there are 14 more dead. So I would encourage you to ask your boss to make that file available to both the ranking member of the full committee, the chairman of the full committee, the ranking member of the subcommittee, and the chairman of the subcommittee. And with that, I would yield back to the chairman.
Thank you, Mr. Chairman. I also want to thank the gentleman from Texas for letting me go in his spot. Mr. Secretary, I've been on this committee for almost 5 years now, and I have listened as witnesses primarily called by our colleagues on the other side of the aisle have repeated with almost catatonic frequency certain phrases like citizenship for 11 million aspiring Americans, as if 11 million of any category could all pass a background check. Phrases like functional control of the border. Phrases as benign sounding as sanctuary cities. And I've listened pretty carefully, Mr. Secretary, as I've heard argument after argument after argument made against empowering state and local law enforcement to actually enforce immigration laws. Have you had a chance to look at the criminal history of Mr. Lopez Sanchez?
I believe I have, yes.
It dates back to 1991. The criminal conduct occurred in 5 separate states. He's committed local, state, and federal crimes. He was and is, by any definition, a career criminal. He violated at least 3 separate statutes when he simply picked up the gun before he shot and killed an innocent woman walking with her father. So, to me, Mr. Secretary, he is Exhibit A that we must not have functional control over the border, or he wouldn't have re-entered so many times. And he is, I'm assuming, not able to pass anyone's background check. I would hope that somebody with this criminal history couldn't even pass our friend in the Senate's comprehensive immigration reform background check. Now, I want us to look at a legal issue in a second, Mr. Secretary, but I want to read a quote to you, and I want to ask you if you know who said it. I want people who are living in this country undocumented to come forward, to get on the books and subject themselves to a background check so I can know who they are, and whether it's the current DACA program or a path to citizenship, whether it's deferred action or earned path to citizenship, from a Homeland Security perspective, I want people to come forward. Do you know who said that?
Well, I don't know if I said it or not, but that is consistent with my own sentiments, so I could have said that.
You did say that. Now, I want you to tell me what in Defendant Lopez Sanchez's background leads you to believe that he would, to use your words, come forward.
Well, clearly, he is not the type of person that would ever qualify for any sort of deferred action.
I know that, nor is he the type of person that would come forward, Mr. Secretary. So my point is, when you have a porous
sentence, sir?
Sir?
May I be allowed to speak?
You are welcome to answer the question that was asked, yes.
Well, give me a chance, please. He is not any kind of person who would qualify for any type of version of deferred action in my book or earned path to citizenship. He is a criminal, a dangerous criminal, multiple times over. When we talk about encouraging people to come forward, what we're talking about are people who we hope will report crime, who will participate in American society fully. Obviously, somebody like this is not coming forward.
No, he is not coming forward, Mr. Secretary. I'll let you answer the question, Mr. Secretary, but I'm not going to let you run out the clock. You're right, he's not coming forward, and he doesn't need to get on the books because he's already been on the books. In fact, better than being on the books, Mr. Secretary, he was in federal prison. So I want to know, why was somebody in federal prison with a federal detainer on him released to a sanctuary city?
You'd have to ask the Bureau of Prisons.
Have you asked the Bureau of Prisons?
We've had a detainer on him, both when he was in BOP custody and when he was in the custody of San Francisco.
I know you did. My question to you is...
I'm quite sure that there are a lot of questions being asked right now. In my book, he is Exhibit A for why jurisdictions need to work with our priority enforcement program. Secure Communities was not working. There were over 12,000 detainers of mine that were not acted upon.
Well, then why don't you make them mandatory, Mr. Secretary?
Working.
Why don't you make the detainers mandatory?
If cities like San Francisco are not complying with federal detainers, why don't you make them mandatory?
I think that would be a huge setback in our ability to work with state and local law enforcement, and I suspect they would agree as well.
Well, I do not agree, and I'll tell you why I don't agree, Mr. Secretary. What I find ironic is you are not willing to mandate federal detainers, but you are willing to mandate that state and local law enforcement cannot assist you in enforcing immigration laws. I mean, help me understand that. You can empower a city like San Francisco to ignore federal law, but you won't empower state and local law enforcement to actually enforce immigration laws. Help me reconcile that.
Can I speak?
Yes, sir. You can have the rest of the time.
Thank you. Thank you for giving me 7 seconds.
Now, you take all the time you want to answer the question, because
Sir,
I think it's important.
I'm sure you're aware of this. The Secure Communities program was hugely problematic in the courts. The courts were saying that state and local law enforcement does not have the authority under the Due Process Clause of the Constitution to hold people until we could come and get them. Last time I looked through federal legislation, you cannot rewrite the Due Process Clause of the Constitution. So that is a problem. I do not believe that mandating through federal legislation the conduct of sheriffs and police chiefs is the way to go. I think it will be hugely controversial. I think it will have problems with the Constitution. I want to see us work cooperatively with state and local law enforcement, and I believe that they are poised to do that.
Well, my time is up, Mr. Secretary. The last time I looked, we had a supremacy clause, and federal law trumps state law, so God knows it trumps the law in San Francisco. And when I hear the phrase sanctuary city, as benign sounding as it is, it may have been a sanctuary for that defendant, but it sure as hell was not a sanctuary for a young woman walking with her father. So at a minimum, change the name of whatever benign sounding program cities like San Francisco want to follow, and the money ought to be cut, and I would hope that you would insist that federal detainers be honored and not be discretionary. And with that, I would yield back to the chair.
So let me start here. Have we ever gotten it wrong in the past? I'm not talking about Syrian refugees. I'm talking about any category of refugees. Have we gotten it wrong? Has our vetting failed in the past? Is anybody aware of a circumstance where our vetting has failed in the past? Not all at once.
I'll take that one, Congressman. The answer is yes, many times. Just earlier this year, an Uzbek refugee, admitted as a refugee, was convicted of assisting terrorism. A couple of years ago, 2 Iraqi refugees in Kentucky who had been admitted, it turned out they had their fingerprints turned up later on IEDs. And so the critics of skeptics, the defenders of bringing Syrians, they insist on saying no one has been convicted, no refugee has been convicted of no Syrian refugee has been convicted of terrorist activities in the United States. But these Iraqis killed Americans abroad. That doesn't make me feel better that they didn't do it here.
The conviction doesn't mean anything to me. The terrorist attacker is not going to be convicted because he's dead. So you can't use conviction as a barometer for whether or not somebody has been a threat. They may not be around to convict. So does anybody disagree that there have been failures in vetting? Does anybody take the position that we have made no mistakes?
Chairman Gowdy, I agree with you that in the history of the 3 million refugees who have come here, there have been a handful who have been a threat to the United States. And fortunately, they have been stopped before anything bad happened. And the 2 Iraqis in Kentucky were the most shocking example. They had done bad things in Iraq, they had lied to get into the country, and had our current system been in place, they would have been caught before they got here. And that's why the system has been improved since that episode. You had said few things in life are risk-free. I heard the governor of Washington State say you take a risk when you get out of bed in the morning. I mean, there's a lot of dangers in the world, absolutely. But I think the program that we run does as much as humanly possible to reduce the risks of bringing refugees to this country. And we have great confidence in it. And we invite members to come out to the field and meet some of the people who interview the refugees and sit through some of the briefings by Leon's team that I've sat through. It's a very impressive, a very thorough event.
And Ms. Richard, that's what makes me hate waste, fraud, abuse, deception so much. And there's an application process which includes some level of investigation on our end. And as I understand the application process, it may well be that USCIS and the State Department have some level of engagement, at least at the application process. And then, as I understand it, there is or is supposed to be an in-person interview at an embassy or a consulate, which is another level of investigation. So you have the application, which may involve USCIS and the State Department. Then you have an in-person interview. And the way I count, that's at least 2 and maybe more levels of inquiry or investigation. And then we fast forward, the FBI director today, I believe, tells us that there is evidence that the female terrorist was radicalized 2 years ago. And there's a media account, and you are free to put whatever stock you would like in a media account, but it's been widely reported that the male terrorist was part of a plot in 2012 to do harm in this country. So it appears to me that the investigations done by our government would have occurred after both her radicalization and after his previous plot to commit an act of terror. And yet the visa was approved. And she immigrated here, and 14 body bags later, we are trying to figure out what went wrong. So, assume arguendo that the FBI is right. Which is not an unreasonable assumption. The female terrorist was radicalized well before her application to come to the United States. How did we miss that twice?
So again, I will take that question as a hypothetical, given my inability to speak to the specific factual scenario. I think in addition to the interviews that you described, individuals are also vetted against law enforcement and intelligence databases at multiple stages in the K-1 visa process. So when we adjudicate the petition by the U.S.-based person, usually the fiance on our side of the ocean, there is a series of background checks done at that time. The State Department does another more fulsome series of checks, and then we see that individual then again at the time of adjustment once they are in the United States. The nature of the interview depends on what derogatory information we have about the individual. So in the absence of a specific we ask a series of questions that obviously are intended to vet that individual out, but in the absence of a specific basis, we probe basically the record that is before us. One of the things that we are looking at right now, and again, I think about this not just in terms of the fiancé visa program, but I really think of it in terms of everything that we do. Are there things that we need to be doing differently prospectively to probe even more deeply to ensure that we are not admitting individuals who will come here to do us harm?
I wholeheartedly concur that we should be looking at all visas no matter what letter occurs in front of them. It just so happens that this is a K visa, but the analysis could very well be the same regardless of what kind of visa it was. And what I'm not trying to put words in your mouth, but what I hear you saying is we don't know if anything would have been done differently, and it's a thorough investigation, and yet we still missed it, which tells me that I have to go back to South Carolina and tell people there's just going to be an error rate.
Well, you know, one of the issues that we're looking at are what are our authorities at different points in the process. So, for example, at the point when we adjudicate the petition, as it stands right now, as long as the bona fides of the petition are established by the U.S.-based petitioner, regardless of what derogatory information may exist against that individual. We don't at that, and again, I'm talking generally. I'm not talking about this, any specific case. That is certainly an issue we're looking at as to whether we need to think differently about what we do in that stage of the process. We're also looking at what we do on the back end of the process at the time when we actually give that person a green card, or we give them a conditional green card. Are there additional measures we need to be taking at that stage as well?
Director, do you know whether or not the female terrorist in California was interviewed in person at an embassy or a consular post?
Again, respectfully, Chairman, I am not at liberty in this setting to talk about any specific. Now, I can tell you what our practice is. Generally, there have been exceptions to this. Generally, it is our protocol that we do not, we only interview people in the K-1 visa program in cases where there is some issue that needs to be explored as part of the case. That could be derogatory information about the individual. It could be factual questions, not necessarily derogatory about the application. That is the existing practice as we speak. That's certainly going to be part of our review.
Do you know how long the investigation lasted from the time she applied for a K visa until the time she was interviewed at whatever consular post or embassy?
Again, I am not at liberty to discuss a particular case. That can be from the time they get in. If I'm understanding the question, from the time they're interviewed at the consular post to the time that we adjust them. Is that the question, sir?
I was more interested from the time she applied until the time there was whatever first interview, whether or not there was research done into her school, if any, attended, social media, if any, employment history, if any, and I'm out of time, so I'm going to go to the general lady, and I'll give her exactly the same amount of time I took. I'll just tell you this, I appreciate, because I hear it a lot from administration folks, that they cannot discuss an ongoing investigation. I would just note the obvious. They're dead. So I don't know that we're terribly worried about their privacy considerations. And I'm not lodging this allegation at you specifically. I can just tell you, I've been around 5 years now, and it just strikes me that sometimes folks cite an ongoing investigation or prosecution when they just really would prefer not to answer the question, because there's not going to be a prosecution of either one of these terrorists. You and I agree on that. So I'm not sure what we're worried about jeopardizing by allowing Congress to look at her file. What investigative or prosecutorial strategy would be jeopardized by allowing Ms. Lofgren and I to look at her immigration file?
Again, I'm really citing the general practices in rules. I mean, I think you and I are both aware of cases where, in fact, regardless of the fact that there may be two dead perpetrators, where there are still actually investigative reasons to maintain secrecy. I'm not speaking necessarily to this specific case. That is the practice that I have lived by, be it in my role as USCIS director or when I was a prosecutor previously. That I did not talk about cases that were ongoing, regardless of those characteristics. I understand why this body would want them. I understand why that information might be helpful to this body in discharging its responsibilities. I do not see myself as at liberty to share that information at this time.
Terrorism, if a woman's raped? Do you, Mr. Burson?
Do I think that that is terrorism?
Yeah.
No, but it's an egregious, horrible crime, which is the father of
I
three
tell you what,
daughters, I think is a horrible crime.
It is for that woman. It is for that family. And you don't deport them. How do you do that? You give them an excuse to make a decision, put some poor officer there to say, you know, maybe they should go ahead and stay here in this country. We had more than 66,000 criminal aliens in your control, and you let them go. You didn't deport them, you let them go. Why do you do that?
Mr. Chairman, the policy provides that if they are a threat to national security or border security or public safety, that they are eligible.
Give me a scenario when a woman gets raped and the person's here illegally, that they're not a threat to public safety. Explain to me that scenario.
I didn't say that. I said that they would be subject.
That's what the memo says.
They would be subject I believe the memo says, unless they are a threat to border security, unless they are not a threat to border security, national
How are they
security, or
not
public
a
safety.
threat? How are they not a threat to public?
If a woman is raped and the perpetrator is convicted of rape, that is a felony, that is a serious crime, that is a top priority for removal. So
No, it's not. It is not the top priority.
I'm not sure
It's
where
priority number 2 for the Department of Homeland Security, so says the memo.
that person would be removed.
It doesn't say that. It says unless there are factors indicating the alien is not a threat or should not therefore be an enforcement priority. Jay Johnson went out of his way to tell people if you commit rape, if you're in a DUI situation,
I do
if
not.
you commit burglary, don't necessarily deport these people.
Respectfully, Congressman, I don't think you are reading that policy correctly.
Rape
is a serious crime that is a removable offense.
It is a
That
removable
is the
offense
policy.
unless, and it's priority number 2 for the Department of Homeland Security. I want some answers about that. I'm going to give you a copy to read. You're going to have a half hour to go through it, and I want to understand why you let 66,000 criminal aliens remain in the United States of America. That's a threat to the homeland. That's a threat of terrorism. That's a threat to every American. Those people should be priorities for removal, and you had them in your possession, and you let them go. You did not deport them. These are people that State Department, who gave a visa, thought about it, got more information, and decided, we better revoke that. 9,500 were tied to terrorists. And you don't have a clue who they are, do you?
No, Mr. Chairman, please understand that I head up the Office of Policy. The operational components that would have that information are
When will I get that?
National security and public safety are not simply factors to be considered in the administration of some broader policy objective. National security and public safety are the ultimate policy objectives. The safety and security of our fellow citizens should be the driving force behind all decisions that we make as representatives. And as representatives, it would be incongruent for us to undertake any act or fail to undertake an act calculated to jeopardize the safety and security of those who sent us here in the first place. People do not employ us to represent them so we can take risk with their security. They send us here to put their security at the top of our constitutional to-do list. This country has a rich and long history of welcoming those fleeing persecution. We have a long and rich history of liberating those suffering under oppression. We are the most welcoming country in the world, and we are the most generous country in the world. And we help those in need both here and abroad, and we administer that aid in greater quantities than anyone else. Our country has welcomed over 3 million refugees since 1975. We consistently provide aid to those in need. We provide protection for those who cannot protect themselves. And we provide a defense for those who are defenseless. Regrettably, the world we find ourselves in is imperfect and seemingly becoming more imperfect. It is because we are free and secure and an orderly society rooted in public safety that we are of being generous to other people. Rather than address the underlying pathology that results in displaced people, those in charge of our foreign policy seem more interested in treating the symptoms. There are refugees from the Middle East and Northern Africa because those regions are on fire and riddled with chaos, and our bright lines and policies of containment and smart power, or whatever we call it today, have failed. Terrorists took the lives of over 100 innocent people in France and injured many more for no other reason than the fact that they could. They killed 100 because they couldn't kill 1,000. And their objective is evil for the sake of evil. It is murder for the sake of murder. It is wanton and willful violence, premeditated depravity, calculated to take as many innocent lives as possible. The acts of barbarism committed against the people of France are the latest in a long line of malevolent acts committed against innocents. And that line is not likely to be over. CIA Director Brennan said what happened in France was not a one-off event. We also know ISIS terrorists are intent on finding ways to attack America and our allies, including here. Director Brennan said ISIS has an external agenda they are determined to carry out. Another administration official said, I wouldn't put it past ISIS to infiltrate operatives among refugees
So that's a huge concern of ours. Those are not the words of some GOP presidential hopeful. Those are the words of our very own intelligence officials who serve this administration. The president has said he's too busy to debate the critical issue, and unfortunately what passes for debate in this political day and age is some absurd conclusion about widows and orphans. It is precisely that kind of hyper-partisan conclusion designed to cut off debate rather than discuss foreign policy that united this country in only this one fact. We have no idea what our foreign policy is in the Middle East. The people I represent are kind and generous, and they are asking this administration and this president one simple question. What assurance can you give us with respect to our public safety and national security? And so far, no one has been able to provide that assurance. On Monday, the president said the country would continue to accept Syrian refugees, but only after subjecting them to rigorous screening and security checks. Those are wonderful words. But at some point, you have to ask, what does that mean? And the head of our own FBI said the concern in Syria, the lack of our footprint on the ground in Syria, that the databases won't have the information we need. So it's not that we don't have a process, we don't have any information. So you're talking about a country that's a failed state, that doesn't have any infrastructure. All the data sets, the police, the intel services you normally would go to and seek that information don't exist. That is not a Republican presidential hopeful. That is the head of the FBI. He also said we can only query against that which we've collected. And so if someone has never made a ripple in a pond in Syria, or I'll add any other place, in a way that would get their identity or their interest reflected in our database, we can query our database until the cows come home. But nothing will show up because there is no record on that person. Lastly, he said, I can't sit here and offer anybody an absolute assurance that there's no risk associated with this. So the question then becomes, what amount of risk is acceptable? If our experts are telling us this is not a risk-free endeavor, and few things in life are, but someone's going to need to tell me and the people I work for what amount of risk is acceptable when you're talking about national security and public safety. And I'll say this in conclusion. The president said widows and orphans. With all due respect to him, what I'm really afraid of is a foreign policy that creates more widows and orphans. So where maybe he ought to start, is a foreign policy in the Middle East, including Syria, where people can go back to their homelands, which is their preference, go back to their homelands. Maybe you ought to defeat that JV team that you thought you had contained. That would be the very best thing you could do to help people who aspire to a better life. And with that,
It's got the DHS letterhead at the top. And the memorandum says, and I'm quoting from it, ICE's refugee program is particularly vulnerable to fraud due to loose evidentiary requirements, where at times the testimony of an applicant alone is sufficient for approval. As a result, a range of bad actors who use manufactured histories, biographies, and other false statements, as well as produce and submit facetious supporting documentation, have exploited this program. And the memo goes on to note that in many instances, the applicant for a benefit, including both asylum and refugee status, receives a government-issued document that contains the biographic information that the applicant supplied. This document can then be used for many things, such as obtaining a driver's license. Now, this strikes me as a recipe for fraud, that if we are allowing refugees to come in without supporting information, tell us who they claim to be, and we're letting them in, despite the fact that the director of the FBI has told us they cannot vet these refugees to make sure they're not terrorists, how can we possibly be confident that the refugees coming in are not, in fact, terrorists seeking to murder innocent Americans?
What I am telling you is that I would not give that document a whole lot of credit, because whoever that person was did not do the homework to learn about our process. We can talk about real gaps, real issues, real areas of risk. That document was written by somebody who did not take the time to familiarize themselves with our program.
Do you disagree with the passage I read, though?
I disagree.
So is it true or false that the testimony of the applicant alone can be sufficient for approval?
It is considered, it depends on the case. Usually we do have extensive documentation. Syrians in particular present with extensive documentation, passports, military records. So there is documentation that we review. In fact, if you come to one of our refugee settlement centers, you'll see piles of documents.
Mr. Rodriguez, it's a very simple question. My time has expired, but I just would like to get an answer to this question. Is it true or false that the testimony of the applicant alone can be sufficient for approval?
There are cases where the testimony is not necessarily corroborated by documents, but it is always tested against country conditions and other information. That's why it doesn't lend itself in the way that you're asking the question, Senator.
Are you saying it's true or you're saying it's false? I'm just trying to understand.
No, I am acknowledging that, yes, testimony can be the basis for the grant of a refugee, but it needs to be tested against other information that we know about the country conditions at a minimum.
Thank you, sir.
Well, Mr. Rodriguez, all of you work for the people of the United States. This is the Congress of the United States. We have a right to ask questions. We expect unbiased, objective answers. And he took too long to get you to acknowledge that answer. And I don't appreciate it. And I just tell you, others doubt the validity of this program and how effective it is.